thank you all for joining us as speakers, and for those of you who are joining online, thank you. So James, I'm going to go to you first. It sheds light, on this less understood part of Hong Kong's judiciary. Could you walk us through, sort of maybe beginning by sketching out a little bit, about, how ththese foreign judges have come to sit on the Court of Final Appeal, their role that they play, what countries have participated, those who have sat, who have resigned, and so a number of judges did resign. One of them from the UK, Lord Jonathan Sumpton, when he stepped down, said publicly that Hong Kong was becoming a totalitarian state, while some remain. And maybe you can help to sort of reconcile also some of these contradictions and speak to the finding. Thank you so much. Over to you.
Thank you so much, Michael. You were slightly breaking up for me. I don't know. I think it could be my Wi-Fi. But thank you so much for the question. I think you got it in full. I think that the issue of these non-permanent judges, it goes all the way back to the handover of Hong Kong by the UK, the handover to China, essentially, back in 1997, July the 1st. And it replaced the Hong Kong Court of Final Appeal, replaced the UK's Judicial Committee, the Privy Council, which was basically the supreme authority, the Superior Court of Record, as it was known, under the Court of Final Appeal Ordnance Survey. The court then hears civil matters, also criminal matters, typically a 5-judge panel consisting of the Chief Justice, 3 permanent judges, and 1 non-permanent judge, which is the key point for our discussion today. And they may be from Hong Kong, but are largely from overseas. And these arrangements that sort of found this new handover court were founded under the basic law of the Court of Final Appeal Ordinance, allowing the appointment of judges from Commonwealth law jurisdictions to serve as non-permanent judges. Now, these have historically been both active and retired judges from foreign jurisdictions, and one of the notable agreements between the UK and Hong Kong at the Handover China and the handover was that 2 law lords from the UK, which for our perspective here, Sumption and Neuberger would be those, were to serve on the CFA, and then retired judges could then participate in a so-called private capacity, which brings in all sorts of questions regarding how these judges are backed by the country they come from, or not, as the case may be. And these judges primarily come from the United Kingdom, Australia, Canada, New Zealand, which all share a common law tradition. And so the thing about these judges being on this court that is essentially ran by the CCP mean that they give their prestige, as the first report said, lending prestige to prosecution. They lend their prestige, their common law jurisdictions, their rule of law, their sovereignty to China and to these courts to give legitimacy to the wrongful prosecutions, as you laid out in your introduction.
Great, thank you so much. And maybe you could just share a little bit more about the findings in the report and set the stage. Speaker.
Well, I can't hear. Sorry, I can't hear. Michael, could you repeat that?
Yes, I'm having the same problem. You're falling off. I've unmuted you.
Share a little bit more about the findings.
Yeah, the findings. Yeah, absolutely. So as per the report lines out both the judges that have resigned. It lays out the civil liberties and the undermining of people's freedoms under the national security law, free expression, freedom to protest, freedom to basically have free speech, essentially. But the judges which have resigned, we've got Anthony Gleeson, who is from Australia, who cited age and his declining health as a reason not to renew his tenure, but has been involved in a lot of the controversial rulings, such as the reinstatement of Chow Han-tung's conviction for unauthorized assembly. Lord Jonathan Sumption, who resigned, stating or criticizing Hong Kong's trajectory towards becoming a totalitarian state. He wrote that in the Financial Times and argued that the national security law severely limits judicial freedom and that the rule of law is becoming profoundly compromised, which is an incredible damning verdict, if you like. But that was him. And then Lord Lawrence Collins also resigned alongside Sumption, and he cited the deteriorating political situation in Hong Kong, and he expressed his but he did also express his confidence in the court's independence, which is a bit of a backhanded resignation. And then Beverly McLaughlin, who's from Canada, stepped down, citing personal reasons, age and family time being her reasons, but said that she maintained confidence in their independence, again, like Lord Lawrence Collins of the UK. Despite a lot of mounting pressure around her to resign over human rights concerns. Obviously, she did resign. Lord Nicholas Phillips, again, the UK, he declined to renew his tenure for personal reasons, not political reasons. Again, quite telling that nobody wanted to follow Sumption's resignation and throw Hong Kong in the bin, essentially, their rule of law infrastructure. And then Robert French, who resigned in April 2025 from Australia, noting that the role of foreign judges had become increasingly anachronistic and arguably cosmetic, which again, as the report's title suggests, it is largely to uphold a crumbling rule of law infrastructure that just seems to weaponize some fundamental rights against those that speak out against the CCP.
Yeah, thank you so much, James. Keith, over to you, and I hope you can hear me okay now.
Yes, I can.
Great. So, you practiced law in Hong Kong up until 2019, right before the national security law was imposed, and successfully represented Joshua Wong in 2014, which is a feat really hard to imagine today. Just last week, Australian Hong Konger and human rights lawyer Kevin Yam was barred from practicing law in Hong Kong and ordered to pay 800,000 Hong Kong dollars prosecutors, which has been part of the human rights accountability campaigning to try and hold Hong Kong accountable for this deterioration in human rights, and very much so penalized for having exercised his free expression and testifying before the U.S. Congressional Executive Committee on China. The Law Council in Australia has issued a number of statements expressing their concern over this deterioration in the rule of law in Hong Kong and the targeting of Hong Kongers in Australia. And yet, as we have been discussing, a number of Australian judges still. I'm curious, for you as an Australian, a lawyer who has practiced in Hong Kong, sort of added attention, this put any pressure on the Australian judges to resign? And again, perhaps, how would you reflect on the sort of, evolution, the deterioration in judicial independence, the role that foreign judges play in?
You're falling off, and there are long periods of silence.
Sorry, let me.
I think I got the gist of what you were saying by filling in the blanks, but it is a bit unfortunate when you keep falling off like that, because when I get rather excited about it, you fall away, and I'm left wondering what you're about to say next. But I think I have followed you.
Yeah, if you could just go ahead.
Right. Look, it is actually very interesting, Michael. If I can just divert for one moment, you referred to my acting for Joshua Wong. Really, that was the first time that I think I fully appreciated just how pernicious this whole thing was going to become. I was part of a pool of lawyers acting pro bono and hunting around Hong Kong for people who'd been arrested, the group of 78 in the Civic Square outside the government building in Hong Kong. We eventually found him after about 26 hours through the night, and we found him in a police station in custody. He'd not been given any of his rights. He had not been cautioned. He hadn't been given the opportunity to have a lawyer. He hadn't been charged. And we only found him by me ringing about 30 police stations and simply getting a direct answer as to whether a person known as Joshua Wong was in their custody. We brought him to court on a habeas corpus, and the first observance that we made about how bad this could be was when, after we presented our arguments and the judge said, yes, I think this detention is unlawful and I'm intending to uphold the writ of habeas corpus, when the senior prosecutor for government said, well, we don't agree, but if you're right that it is unlawful, what we would ask is that you allow us to hold him for another 48 hours in order to try and regularise it. And the judge had to point out that having found, if he did, that it was unlawful, there was no question of continuing to hold him. And this came as a real surprise to the Justice Department lawyer, who thought he could be held unlawfully, provided the judge said it was okay for 48 hours. So that was the starting point, and that was back in 2014. Little did we know it was going to deteriorate the way that it has, and ending up with Kevin Yam and, of course, Ted Hoy, who is down here and lives in Adelaide at the moment, being chased with warrants and bounty letters that I'm sure you've heard of, offering $1 million Hong Kong for anyone who could produce Ted Hoy or Kevin Yam back to the authorities in Hong Kong, where they could be dealt with according to law. This is just outrageous and totally unheard of, I know, in Australia. And there was not a single legal authority here who thought that that was ever going to be acceptable. I think the bounty letters were apparently issued by the Hong Kong police, and the warrants were issued under the authorisation of the Department of Justice. So these two poor, I think, poor, one lawyer, one not, poor people escaping from Hong Kong and from the terrible behaviour towards them, were chased all the way to Australia and received letters of threat and menace. There was really no disguise whatsoever. You're right, Law Asia has also issued a number of statements. The one I have is the 31st of July 23, saying that the behaviour towards the lawyers, the warrants, the bounties, they're all outrageous and not to be accepted under any circumstances. The Law Council, as you've pointed out, has made a similar finding. I think I can say with a fair degree of confidence that there's not a single legal or governmental authority in Australia that has sought to defend this behaviour by Hong Kong. And in fact, it's part of what led to a statement from our Minister for Foreign Affairs, Penny Wong, fairly recently coming out and saying publicly that she thought that any person, any judge, former judge, looking to sit on the CFA ought to look carefully at his conduct and think very carefully before associating himself in a judicial office with the CFA. So I think the simple answer to your question is there is an outrage here, and I think it's as deep as I've ever known it to be since I came back in 2020. Does that answer your question?
Yeah. Okay.
You there?
Yeah. Great. Maybe next, I can move to Chloe. Are you able to hear me?
Yes.
Very good. Chloe, as I mentioned, and as many of those joining online are obviously no doubt aware, you are one of the 34 Hong Kongers that are targeted with these abusive arrest warrants. And you've talked about the impact that this and others have had on you, even in the United Kingdom. And yet, a number of UK judges have and continue to sit on the Court of Final Appeal in Hong Kong. I mean, how does this make you feel as someone living in the UK? And how do you see this being reconciled, their own government issuing reports and critiques of the deterioration in the rule of law, and yet even members of the House of Lords continue to sit on the court in Hong Kong?
Hi, everyone. Can you hear me?
Yes, Chloe.
Okay, cool. I wanted to start talking about some background and my personal story as some background information for those who don't know the whole story. I was born and grew up in Hong Kong, and I participated in the 2019 movement as a student. And in 2020, after the national security law was implemented, I decided to leave Hong Kong without risk. And after I moved to the UK, I continued to do activism, and I started working with the Committee for Freedom in Hong Kong Foundation, the organization that I represented today. But leaving Hong Kong didn't actually protect me. Last year on Christmas Eve, when I was just 19 years old, I was charged under Hong Kong's national security law, and the Hong Kong authorities placed a 1 million Hong Kong dollar bounty and an arrest warrant on me for accusing me for colluding with foreign forces and inciting secession. And since then, as Michael has mentioned, I have shared to the media a lot about how I was being harassed online, I was being intimidated, and even being followed on the street of London. And this is the reality of transnational repression. And national security law is a law that designed to silence dissidents in Hong Kong, and now it reaches across border, threatening anyone who dare to speak out in anywhere in the world. And I think on national security law, it is also very important to point out that Article 37 of the law applies to a person who is permanently a resident of Hong Kong and commits the offense under the law outside of Hong Kong. So basically, even if you're a Hong Kong resident, if you say something against the Hong Kong authorities or fighting for democracy in Hong Kong, you could be charged against national security law. And Article 38 of national security law apply to offenses under the law committed against the Hong Kong authorities from outside the region by a person who is not a permanent resident of Hong Kong. So basically, if you are a British citizen and you speak against the Hong Kong authorities in the UK, you could still be charged under the Hong Kong national security law. That is how outraged this law is. And, that all show that the national security law has systematically cracked down on Hong Kong's freedom, the case of Chow Hang-tung, Jimmy Lai, the imprisonment of nearly 1,900 political prisoners since 2019, the shutdown of the whole pro-democracy political parties and independent media provide a clear evidence that the judicial system of Hong Kong has now been used to suppress dissidents. And, these actions are directly violating the promises of the Sino-British Joint Declaration, One Country, Two System, and how Hong Kong was supposed to have a high degree of autonomy. And, yet the UK government, who stated that they are committed to uphold the treaty, little has been done to hold the Hong Kong and Chinese authorities accountable for, these breaches. And as Michael has mentioned, and as the report has mentioned, there are now still two members of the House of Lords, Lord Hoffman and Lord Neuberger, are still sitting in the Hong Kong Court of Final Appeal. And as a Hong Konger, I found that really disappointing and really painful, because when I, look at Western institutes, Western governments, and Western judges who claim to uphold the rule of law, and, here they are still lending prestige and legitimacy to Hong Kong judicial system that crushes every freedom that they claim they champion.
Thank you. Maybe you could also share some reflections about the campaigning to raise awareness and push for the foreign judges to resign. What you have been working on over the last, year.
Yeah, sure. When I, work on my advocacy, I always kind of say that it's not a theoretical problem. Foreign judges in Hong Kong is an actual problem, it's a real problem that give credibility to an increasingly authoritarian regime and a system. And, their presence gave reassurance to investors, foreign governments, and the international community that Hong Kong's judicial system is independent. And we all knew that it is not true. With all these repression continued in Hong Kong, outside Hong Kong, and the authorities are left unchallenged. And, their presence, like foreign judges' presence in Hong Kong, actually emboldened the Hong Kong authorities to extend the reach of the oppressive law globally, because when they have no accountability, they are more bolden to repress on activists like myself and other prisoners and political prisoners in Hong Kong. And for me and for many Hong Kong diaspora, I believe that is really personal, because we saw that our friends, our family back in Hong Kong, or our fellow activists are criminalized for speaking, for writing, or even for waving a flag or wearing a t-shirt. And we saw that human rights are compromised by those who occupied positions of authority in Hong Kong. And they, how can they claim to uphold justice while remaining as part of the system that applies the national security law extraterritorially to punish diaspora? And, talking about my campaigning experience in the UK and elsewhere, I kind of learned that I think people are more response when we connect these issues with human stories. But it's not just about me, also about other 33 activists that are being placed on the bounty and arrest warrant because of the work that they did outside of Hong Kong. And our experience are actually an evidence of the tangible harm that caused when foreign judges legitimize an unjust system. And, the legal community abroad should understand that these appointments are complicit in a global strategy to silence Hong Kongers. It is, for me, really heartbreaking, really frustrating, and it's unacceptable that the moral and legal way that foreign judges brought to the Hong Kong judicial system cannot be ignored. They have the power to withdraw the legitimacy and to challenge the regime, but they choose not to, and that is their choice. That, not just affect people of Hong Kong, but also sending a message that the Hong Kong judicial system is still working and is still independent, and it affects a bigger picture than just Hong Kongers.
Yeah, thank you so much. And I think, really the point that resonates also is the value of connecting it to personal stories, not to make it abstract. I don't know, maybe Keith, back to you, because again, in terms of personal stories, Kevin and Ted are also in Australia, Hong Kongers, lawyers who have been targeted. Could you maybe also share, what is happening in Australia? What's the conversation like, perhaps, for the remaining Australian judges and the potential for pressure on them to resign from the Court of Final Appeals? Sorry, you're on mute.
There is very little pressure at all. I've mentioned that our Minister of Foreign Affairs has made a statement suggesting they do not sit with the CFA. There's been no formal government position taken. One of the difficulties is that, unlike the situation with Lords Neuberger and Hoffman, we don't have anything like the House of Lords, where a retired judge may remain in the Lords and therefore be, in a sense, part of the government structure, whilst holding a position, a judicial position in another jurisdiction. Hence, Hoffman and Neuberger can sit in Hong Kong, even though they are law lords in the House of Lords in the UK. And one of the documents I was reading recently pointed out that that even raises questions of oath taking and a conflict of interest, where there's a conflict between the UK and Wales on one hand, Hong Kong on the other, and they've taken an oath of allegiance to Hong Kong in the CFA, but they've also taken one to the UK and Wales. What do? We don't have that problem. And because of that, the government really has no standing at all about retired judges sitting in other jurisdictions. For instance, our judges have, over many years, sat in the courts of places, of some minor places, if I might say that, not disparagingly, such as the Solomon Islands and Fiji, where judges from Australia have sat on appeal and even in first instance trials in what have sometimes been heavily political matters. They've done that, and there's never been, as I know, any adverse comment about it. And so I think that we've fallen into a situation where we say, well, they're doing what they're allowed to do, as long as they declare their income from Hong Kong sitting on the CFA to the taxation department here, the government has no particular problem. What, however, is changing is, you may well be aware that China has been adopting a very aggressive stand militarily towards Australia by circling Australia with warships, by interfering with flights and shipping from Australia in the Taiwan Straits. And there's been a number of cases where we've almost lost Royal Air Force planes as a result of the behaviour of Chinese fighters at sea. Over more recent times, Australia has now taken a very open step of accusing China of running an aggressive policy towards Australia in particular, and that we don't intend letting that go by without comment. We've therefore queered our pitch with China on that level, and I think it's going to be easier for the Australian government to go to people intending to sit at the CFA and say the position vis-a-vis China is such that it would be quite inappropriate to be there. But at the moment, I have to be honest and say there is very little publicity. There is some press cuttings from time to time, but they are generally about a specific issue, such as Jimmy Lai and what's been happening with that trial. And there has been publicity about the NSL and the SSNL, but only in very bland terms. So I cannot say that there's been a really aggressive stance by the Australian authorities, nor indeed by the the professional bodies with which I have some contact. The Bar Association, for instance, I do not believe has made a statement. I wouldn't expect them to. I don't think the Law Society here has made any statement either. So you're not going to get an awful lot of comfort from looking to Australia for an aggressive stand, unless the matter of China's constant intrusive behaviour gets more light of day, in which case I think circumstances might well change. It's interesting that over recent days I've made a friendship with Bao Jusao, the political cartoonist, and we were talking to him the other night, and he was saying that even in 2018 he wanted to put on an art display in Hong Kong and got a warning 12 hours before that he better get the paintings out and he better get out before a raid is carried out and he's imprisoned. And in fact, all of his paintings have been sent down to Australia. Some of them were damaged, one of which we've been able to purchase. And he lives down here now permanently, but whenever he goes overseas for giving an art exhibition, he's followed. And almost every gallery he's sought to use has been approached by Chinese agents, warning the owners of these studios that it would be very unwise to allow him to exhibit his material because it's offensive to China. And indeed, most of his exhibits fall through for that precise reason. So what Chloe says about the intercontinental
just earlier this year, and of course the exhibit earlier this year also in Hong Kong, where the gallery organizers threatened legal action against him.
Yes.
Which was quite concerning as well. Just in interest of time, and I see we have a few people who have questions. One moment before we get to the questions, I just want to give our speakers a moment, very briefly, if each one of you, drawing from your comments, if you could just share one recommendation. Where do we go from here? Maybe James, I'll start with you. And then Keith, and then Chloe, very briefly.
Can I just make 2 points? One is my recommendation, and one is a second point that I'll make. But one is that the thing is that all these remaining non-permanent judges need to resign, and they need to stop legitimizing authoritarianism, stop undermining their own rule of law, common law jurisdictions. And that's essentially the only thing that needs to come out of this. So the journalists in the room is putting pressure on foreign offices, on the judiciary, on the justice ministers to I know we've got a separation of powers in all these jurisdictions, but to basically say, look, you're doing us a disservice by continuing to act in these courts and giving legitimacy to communism and the communist regime. And then the second point, which I'll just quickly make, is that this continues to go on in terms of, on the 9th of July, Hong Kong's Justice Secretary Paul Lam gave a speech in Paris where he continued to maintain this charade of judicial independence and Hong Kong's autonomy, and whilst it continues to engage in transnational repression, as Chloe has stated. And this just continues to give judicial credibility to this system that is totally corrupt. And I think that this is something that journalists should be more aware of, that this continues to happen, and that this sort of long arm of Hong Kong's authoritarian rule of law, that they continue to do this world tour of grotesque lambasting of their own independence.
Thank you, Keith. Over to you. Brief recommendations. Yes. Where we go from here.
Can I have a small indulgence in time? I prepared this on the basis that I'd probably have a 10-minute say, which I probably won't, but I do want to make a couple of comments because there are things I do disagree with in the paper and some of the things that have been said tonight. And I want to make a statement. It will take me maybe 5 minutes to read. Do I have that time or not?
Yes.
Can you hear me?
2 minutes, please. Yeah, 2 minutes.
Oh, 2 minutes. Okay. I'll cut it down. I just want to say that the use of the word in the topic, I've taken objection to betraying, because I don't think there is a betrayal here. Now, when I say that, I mean, I don't think there was an intention on part of the Australian judges. I do not speak on behalf of Neuberger and Hoffman, but I don't think there was an intention to bolster the sort of legal regime that is now current in Hong Kong. I believe that when they started, it was intended to be a helpful avenue for the CFA moving to a whole new form of work, to have experienced senior common law judges helping them. So I don't like the word that there was a betrayal. I'm also not sure what it means by betrayal of the law, but I will leave that for now. I think that the non-permanent judges did serve a useful purpose at one stage, but I think that was a very long time ago. I think that the present and past Australian MPJs have not consciously tried to crush freedom of human rights and freedoms in Hong Kong. And I say that because all of them, without exception, have taken a very broad and liberal view in their work in Australia. And I find it very hard to believe that they've suddenly become draconian simply because they're in Hong Kong. But I believe that in the years up to about 2019, things started to go wrong, and 2020 has caused what we now have, which is a totally unacceptable situation. In my view, the Australian judges have no right now to sit at the CFA. They have no right of any standing in Hong Kong. Their appearance there certainly causes serious superstition, or suspicion, I should say, sorry, suspicion about what their motives are. Why are they there? Are they there to give legitimacy to the Court of Final Appeal and the Hong Kong legal system? And I think people who feel that are right to feel it. But I don't think in truth that's why they think they are there. So I believe, and colloquially it could be said, that you're judged by the company that you keep, and serving in the HKSAR in a judicial capacity in light of post-2020 developments could easily be misread by many jurisdictions as consorting rather than simply providing a legal service to the CFA. And I just in closing want to say, for those who say it should take more than mere presence in the CFA to inculpate an NPJ with a draconian judgment out of that court, whether after an Article 158 reference to the Standing Committee or not, I would simply say, as the law has now demonstrated in Hong Kong, that mere presence at what is described as an inappropriate meeting, or in this case, inappropriate judgments, simply being present, in my view, could lead to a custodial sentence without proof of intent. And the courts in Hong Kong have made sure they don't require intent in all cases. So you could make the same accusation against the NPJs that they may not have intended anything, but the mere fact that they're there under the law as it presently is in Hong Kong could give rise to a criminal charge. Of course, it won't in the case of a judge. But I'm simply saying that there's one rule for some, rules for Chloe, and rules for non-permanent judges who consort and behave this way and give support to a system, whether or not it's their intention to have the result that's come about as a result of their presence there.
And Chloe, maybe, to reflect, to respond to that if you'd like, but also thoughts you have, recommendations and where we go from here.
Yeah, maybe just a short response to Keith's point. I would say that I don't know their intention. I don't know whether they are, they are sitting on the Hong Kong Court of Final Appeal intending to legitimize the court, or whether they just want, their salary, or whether they want to help. I don't know what their intention is. That's what I would say. But I think if their presence was originally intended as a legacy of Hong Kong colonial past, to maintain international standard, to boost confidence of the city's legal system, and to demonstrate the commitment to the common law tradition, then I would ask that, does their sitting still serve the purpose today? And if not, why should foreign judges continue to endorse and lend credibility to an eroded judicial system? That is what I would ask them. And I mean, if any of the foreign judges are now watching this webinar, or if this webinar is shared to you, I think you should also ask yourself the same question. And for governments, for bar associations, I think they should actively discourage continued participation of foreign judges in Hong Kong, because I have mentioned all of the reasons above, and this could include coordinated diplomatic statement, that could include guardians from bar associations. And I think if you're a journalist listening to this, maybe report on these foreign judges, give more public awareness, and raise awareness of they are indeed still sitting on the Hong Kong Court of Final Appeal. And I think legal professionals should also be advised to withhold engagement with the Hong Kong judicial system until credible protections for judicial independence and fundamentals freedom in Hong Kong are restored.
I agree with all that you say, Chloe, all that you say. They should not be there. They should be gone. They should have been gone some time ago. They serve no purpose now. If this Court of Final Appeal can work its way through common law and through legislative and common law construction of legislation and regulations, they shouldn't be there. If they can't swim on their own account, then the courts need to have a look at who they're appointing and do something about training or giving them more support for people to help them with their research. Certainly, it should not be Australian NPJs there in those chambers with any role or standing whatsoever. It's unnecessary, it's flagrant, and it's definitely provocative.
Very good. Thank you so much for that. Lively back and forth as well. We have some time left for questions. Could briefly just identify yourself before you ask your question. Please keep your questions brief, questions, not statements. And I believe we have one already. Latika, I think you. Let's see, are you able to?
I think she's unable to.
If you should be able to speak. Okay, maybe you can type your question if you're unable to speak. In the meantime,
can you hear me now?
Yes, very good. Thank you. Please.
Oh my
go
gosh,
ahead.
I'm so sorry. Sorry, these settings always change every different app you get on. My apologies, everyone. Chloe, nice to see you. Keith, I'm Latika Burke, reporter for the Nightly Australia.
Hi.
Keith,
Hi.
I think my question is probably for you. So a couple of years ago, the Five Eyes countries had a situation where Australian and American and British former military personnel were going and training with the Chinese. And the governments then decided that this should be illegal and that they would change laws to make sure that this could not happen and to capture this new thing. Is there a point where we have to decide, given the national security law and given the way that we all now deem Hong Kong widespread across the Five Eyes, that this actually should be illegal to sit on the courts?
Certainly, it would be possible to do that. There is a difficulty in bringing it in because it would, in effect, be a retrospective provision. They retired with their pensions without any condition, and there would be an argument, I should imagine, that they would say, well, you may want to do that with future retirements, but we retired without such a condition. I think that more than making a formal legislative or regulatory change to what former judges and judges on a pension, a federal pension, which is relevant, about whether they could serve on an overseas court, it's more likely to be successful if there's more of a public outrage, if the bar councils throughout Australia and the solicitors' councils all came together to make joint statements. I suspect that the 3 judges who are presently there, and I don't think there'll be any new ones, I hope not, but the 3 that were there, I have very little doubt that they would reconsider their positions and leave. But at the moment, particularly with Gummo, who's a particularly aggressive individual, he may try to stay on, but I think the other 2 would probably yield and stop. And certainly if the British judges stop, that will be the end of the practice as a whole. But if that was not to work, then I think consideration would have to be given to a change in probably, I don't know whether it would be the civil service rules, because the judges are independent appointees. I don't know who would control what they could do after, but it may be possible. I know I've seen a suggestion that it may be done, but the general feeling is that it would be the last step, that they wouldn't want to trammel former judges who are Chief Justices of the High Court or Chief Justices of the Federal Court to have them the subject of a legal amendment to their status. I hope that answers your question.
It does. May I quickly follow up? Keith, what is your assessment of why the Australian legal community has been reluctant to issue statements condemning this?
Yeah, I've spent some time thinking about it. To be perfectly honest, Hong Kong doesn't seem to be the centre of attention that it used to be. Prior to these troubles, if I can call them troubles, particularly in 2020 and then 2024, people who used to travel to Hong Kong frequently have stopped. There are still business people going, but they seem to make very quick visits. As a result of this, there is very little discussion about what is going on in Hong Kong. I have friends who are lawyers, I have friends who are professionals, but not in law, who every time I see them, they say, has anything gotten better in Hong Kong? And when you talk about, well, there's a problem with these NPRs and whatever, they say, oh, I didn't, what's that about? I didn't know about that. They don't know that much detail. All they know is that China's being difficult, Hong Kong's in trouble, or that's how they see it. But they don't seem to know the details of how this is all coming about. And I guess, like most other things, they have other problems to worry about, cost of living, economic questions. And I suppose they think, well, China's just too big anyway. Whatever China wants to do, it'll do. We can't do much about it, so let's get on with our lives. I know that's sad, and I know it's a depressing thought that people in Australia could be so disinterested in what's happening to 6 or 7 million people in Hong Kong. Unfortunately, that's just the way the world is. I think there's also, of course, a lot of attention being given to Gaza, the Ukraine. In a bucket list of things you don't want to get involved with, I guess Hong Kong would be somewhere down the sides of the bucket rather than in the forefront. If that's your answer, I'm the best I can do, I'm afraid.
I don't see any other hands up. If anyone else has a question, please raise your hand. Otherwise, James or Chloe, if you have any thoughts or reflections on
Okay, yeah, thoughts and reflections. I think this would have made your point now with this in terms of I agree with Keith in large respect, in so many respects of what he's just said, and I don't see there's going to be any more judges from Commonwealth jurisdictions joining this court. It would be utterly damning and utterly shameful and stupid thing to do, and I think right now it is about getting these judges to resign. And I agree with Keith when he says that if the UK judges resigned, then the other judges, the Australian judges, would follow suit. And I agree. The UK is seen as this bastion of the rule of law. We've got the House of Lords, the constitutionalism of free speech, and I think that if those 2 judges did resign, it would then mean that everybody was totally shot, and they are already totally shot on credibility. But it would leave very little in the way of way of a backing to remain on the court. I think in terms of maybe for journalists, if there's journalists on this call, is to basically continue to push these the bar associations and the judiciary and also these judges to get an answer from them, because they seem quite above it all and unanswerable to anybody who questions their authority. And yeah, I think that would be the but I think it's going the right way. There's been a lot of to and fro when we were writing this report about things that were happening and things that were coming out as and when it was being written anyway. So and no amendments were being made, so there is movement on this still, but yeah, if those judges would all resign, that would be great. And maybe another point would be that judiciary should issue some sort of ethical guidance on I know this is in the report, page 9 I believe, on acting in jurisdictions like Hong Kong, and that guidance should be given, and that should be made to be followed. But that's yeah.
Chloe, do you have
Can
any,
I just ask?
maybe closing? Sorry, yeah, Keith.
Can I just say, if in fact we should, with the greatest of optimism, get rid of these NPJs, whether they're from Canada, England, New Zealand, doesn't matter, Australia, what do our two friends, Chloe and James in particular, think about? Would they be replaced? Would they be replaced by non-permanent judges such as Kemi Bakari, people like Henry Litton? How do you see them being replaced? Would we just have a 5-man bench of the CFA? Would we have non-permanent judges but not overseas non-permanent judges? Do you have any idea of how we would replace them?
Two thoughts on that. I think we would have MPJs, but not overseas MPJs. But again, it doesn't bolster legitimacy, because the legitimacy comes from these, common law jurisdictions and these Western heavy jurisdictions. So it doesn't really matter. I don't think it will bolster it in any way, shape, or form. It would just exist in its own sphere, which is fine. You from that perspective, I think. But there is a lot of work that then will need to be done on how these cases are monitored and how people are then assisted through organisations like CFHK, like Article 19, and I think monitoring free expression needs to be a continuing thing, even if MPJs were not on these courts. But getting them all to resign would be fabulous.
Thank you, James.
And Chloe, maybe final thoughts from you.
Yeah, just replying to Keith's question first. I would say that I think the Hong Kong authorities would try their best to have non-permanent overseas judge, even if Lord Neuberger or Lord Hoffman resigned. I think they would still use whatever way they can to have another overseas non-permanent foreign judge to replace them, because I think so far, as far as I knew, I think the Hong Kong authorities and the Chinese authorities knew too well about how human works. They knew how to threaten people. They knew how to give benefits to people, and for them to, sacrifice their value and work for them. So I wasn't that. I think the Hong Kong authorities would try their best to have overseas non-permanent foreign judge. However, we should still continue to do what we're doing, to point that out, to say that it's outrageous, to raise public awareness, because that would help Hong Kong. I knew that a lot of things had happened and is happening around the world, which makes Hong Kong getting less attention than it used to be. But given that, the national security law is still cracking down on Hong Kong freedom, there isn't any legal certainty in Hong Kong anymore. There's no room for dissident, no room for freedom of speech anymore in Hong Kong. I think, people are still being affected every single day, even though there isn't attention on Hong Kong. So I think, what we're doing here, what we're doing today about this report is really, really, really important. I don't know how much attention we can get, but I think what we need to do is to have hope, and to try our best to, raise awareness and do whatever we can.
Thank you.
Sorry, Michael, can I just say one last thing, which is I think these judges remaining on these courts is largely symbolic as well. They're all getting on a bit, to put it politely, and I think that there won't be any more joining, I hope, and it's just going to be symbolic that their faces are on websites. I don't think they sort of lend any practical legitimacy. It's just having their faces and saying, "Oh, look, big name from a Commonwealth jurisdiction is on the court."
Yeah. Thank you, James.
Well, Chloe, James, and Keith, thank you all so much for this conversation. And for those who are listening, thank you for joining online. We have recorded. We will make this available. And everyone, please also look for the new report from the Committee for Freedom in Hong Kong Foundation, Still Lending Prestige to Persecution, Why Hong Kong's Foreign Judges Disgrace Common Law Tradition. And I have been Michael Castor. Thank you for joining us.
Thank you, Michael.
That's it.
Thank you.
I can close now.